Okay, so again, welcome everyone. My name is Sarah Harris, and I am the Director of Education at the National Constitution Center in Philadelphia. I am so pleased to be with everybody today as we talk about First Amendment rights, including freedom of speech and of the press. We are so lucky to be able to do this session in kind of partnership with the Los Angeles County Office of Education. And we have with us today Craig Lewis from that office. So Craig, I know that you kind of shared a little bit already about these sessions in the past. This is my first time joining us for the session. So is there anything that you would like to share with our participants before we get started today?
Yes, Sarah, certainly. One of the things that we really propone at the Los Angeles County Office of Education is civic learning and civic life, and helping our students and helping our teachers to help our students to become enthusiastic participants in their civic life and growth in this world. We're really looking forward to ethnic studies because we think that there are some important connections between civics and ethnic studies that we'll see here in California and certainly across our nation. And I think these both civics and ethnic studies have in common that they are areas where, depending on where you are and depending on your perspective, there are questions around First Amendment and freedom of speech and how we share and how we talk about civic life and civic participation, and certainly ethnic studies. So tonight's going to be very exciting for me, and I'm sure for everyone else. So thank you very much for this opportunity.
All right, thank you so much, Craig. So I am going to introduce our scholar in just a moment. Before I do that, I just want to encourage everybody to take some opportunities throughout our scholar talk today to send your questions through the chat. Anything that you are curious about, anything that you've been wondering about the First Amendment, about freedom of speech, please feel free to send it through the chat whenever it pops into your head, and I'll make sure that it gets to our scholar at the appropriate time. So with that, I am so thrilled to be able to introduce our scholar for today. Eugene Volokh is joining us from California. He teaches First Amendment law and the First Amendment amicus brief clinic at UCLA School of Law, where he has often taught copyright law, criminal law, tort law, and a seminar on firearms regulation policy. Before coming to UCLA, he clerked for Justice Sandra Day O'Connor and the US Supreme Court, and for Justice Alice Kozinski on the US Court of Appeals for the Ninth Circuit. He's the author of the textbooks, The First Amendment and Related Statutes, and Academic Legal Writing, and as well as over 90 law review articles. He's a member of the American Law Institute, a member of the American Heritage Dictionary Usage Panel, and the founder and co-author of The Volokh Conspiracy, a leading legal blog. His law review articles have been cited by opinions in 8 Supreme Court cases and several hundred court opinions in total, as well as several thousand scholarly articles. So Professor Volokh, we are so excited that you are here with us today. Thank you so much.
Very much my pleasure. Thanks very much for having me.
All right, and I think that you should have everything that you need. If you need to share your screen or anything along those lines, like I mentioned before, I am happy to share our questions as they pop up in the chat as well. So whenever you are ready, we are ready to get started.
Great. So I had a brief conversation with Sarah up front, and my thought was I'd talk for a few minutes just to give the big picture of free speech and free press law. The very big picture, in a sense, you might think of it as the grammar, so you know what the nouns and the verbs and the adjectives are. And then I'm sure there'll be questions, or I hope there'll be questions, and then I can answer them. And for some of them, I actually may have some PowerPoints that already are a nice fit. Then we can talk, just deal with whatever you folks are interested in. As I think you may have heard, there's a series of 10 videos that I put together called Free Speech Rules. It's all about setting forth the rules of free speech law. The aim is to be engaging, but really impartial on the subject. And if you can find them on freespeechrules.org. You can find them searching on YouTube for Free Speech Rules. They're aimed mostly at students, including college students, but also high school and junior high school, even elementary school students, and but also, potentially interesting to adults as well. So just wanted to put in a pitch for that. That's a good way of answering, I think, sometimes some student questions about things like hate speech, about college student speech, K through 12 speech, and the like. Okay, so let's talk a little bit about the general structure of free speech law. And let me see if I can make this work. Let's share the screen. All right. Few basic principles. So the most important principle of free speech law is that no viewpoint may be suppressed by the government. Government can't suppress revolutionary views, can't suppress advocacy of communism, let's say, or for that matter, fascism. Can't suppress racist views, can't suppress religious views or anti-religious views or sexist views or anti-gay or pro-gay views. It can't suppress, for example, views that are against private property. Take the example of socialism rather than outright revolutionary communism. Can suppress that, to be sure. Private property is protected by the Constitution. It's part of our constitutional scheme, just as equality is, just as democracy is, but everything, including things that are fundamental parts of our constitutional order, can be challenged. And you can say whatever you want about politics, about science, about history, without the government suppressing it, for example, throwing you in jail for it, or fining you for it, or holding you liable for it, and the like. That's the big picture. There are no exceptions for particular kinds of viewpoints. There are some exceptions for certain kinds of categories of speech, defined generally perhaps by subject matter, but let's say defined generally not by viewpoint, with maybe a few exceptions. So, for example, incitement of imminent crime, which is to say crime right away, is indeed punishable. This is there's a case called Brandenburg, so the name of the doctrine is often the Brandenburg exception, which says that sets for three elements. If speech is intended to and likely to promote imminent lawless conduct, classic example being a speech in front of, let's say, a police station, burn it down. Well, all right, that is likely incitement of imminent crime. But that's that. If you were just to put out a tweet saying, yes, it's time for revolution and everybody should feel justified in destroying the instruments of the police state, that is expression of abstract advocacy of violence, and it is not criminally punishable. To be sure, it may make sense for the police to kind of track down who posted that tweet and see if he's actually planning on burning down some police stations. The First Amendment doesn't protect that conduct, but he can't be punished for the speech itself. There's also an exception for so-called fighting words, which are basically face-to-face personal insults that are likely to cause a fight. This includes some racist insults, but also non-racist ones, or anti-gay, or whatever else, but it includes ones that have nothing to do with any particular group status. The one thing in common is they are personal insults. They're said face-to-face, and they're therefore likely to cause an imminent fight. So those can be punishable, again, not because of the viewpoint they express, but because of their tendency to cause a fight, and the sense that precisely because it's so limited, such a narrow exception, it leaves you free to express whatever views you want. So, for example, if you express a political view that's not personalized, that's not like a personal insult to the listener, doesn't sort of address him by name or hey you, the fact that he may want to throw a punch at you doesn't justify restricting your speech. That's outside this narrow exception. There's, of course, an exception for libel, or maybe more broadly defamation, which is to say false statements. And then there's an interesting question: do they have to be knowingly false? Is it enough that they're negligently false? I'm happy to get into that later. But false statements that damage a particular person's or particular corporation's reputation, or nonprofit corporations' reputation. So the theory there is that false statements of fact lack constitutional value. And while you can express whatever ideas you want, the same case that said under our Constitution, there's no such thing as a false idea, you can't say false things, at least when they damage somebody, a particular person's reputation. There's an exception for so-called obscenity. It's a term that has multiple meanings, of course. It's not for obscenities in the sense of vulgarities. It's obscenity in the sense of hardcore pornography. Now, the fact is the war on porn is over and porn won. So as a practical matter, this exception doesn't really matter that much because anti-porn laws are not enforced, even though we're swimming in an ocean of porn. Nonetheless, at least in some situations, this does come into play. There's an exception for true threats. So if I threaten to attack you, or even if I threaten to fire you, for example, it could be true threats, not just of violence, but of tortious conduct. If I threaten to fire you illegally, that is punishable. Note which exceptions don't exist. There's no exception for hate speech. There's no exception for fake news. The court was urged to create a general exception for knowing falsehoods, but it said, nope, there's an exception for libel, these personalized falsehoods, but not fake news generally. Now, it's also important to realize that so far I've been talking about the government acting, one might say, as sovereign, using its power as a government, its power to throw you in jail, which ordinary people don't have, of course, right? Or its power to impose legal liability on you. It would be nice if there were a single verb that says impose legal liability. Turns out there is. It's tumult. That's a lovely word, except nobody knows it. I'm trying to spread it. So one day maybe I'll be able to use it because I told it to you folks and you told it to all your students. But unfortunately for now, I think I'll have to stick with impose civil liability. That's the government's power as sovereign. That's the government's power it has by virtue of being a government. But what about the government as employer? Like many of you folks presumably work at government-run schools. Can the government fire you based on your speech? The answer is it's complicated. And there are special rules that reflect the fact that the government acting as employer is in some measure not acting fully as a government because they're private employers out there, but it is acting as a government in some measure. A government is subsidized, or what the government says, here's a pot of money and we want you to spend it in a particular way. What kind of restrictions can it impose? Government K through 12 educator also has broader authority, but not unlimited authority. So somewhere in between the rules for the government as sovereign, which are quite speech protection, and the rules for private educators, where the First Amendment just doesn't apply, somewhere in between is the rule for government as K through 12 educator. I'm happy to answer questions as they come up. Or a government as speaker. Let's say the government, for example, is choosing what monuments to allow in a park. The court has said that's the government essentially speaking through those monuments. Even if it didn't create them, it chose them, it put them up. And as a result, it gets to choose, including based on viewpoint. So it can't ban revolutionary advocacy, it can't ban communist advocacy, but it can put up a statue of George Washington without putting up a statue of Joseph Stalin, right? That's a viewpoint-based distinction, but the government's allowed to do that because it's the one that's speaking essentially through these statues. Let me just close with one more section. What about private restrictions on speech? So this is one of those things where a little knowledge can be a dangerous thing. The little knowledge as well, they're not a First Amendment violation, and that is absolutely right. The First Amendment, the first word of it is Congress. Congress shall make no law. 14th Amendment applies that to states, no state shall, and also to school districts and other local entities that are agencies essentially of a state. None of that applies to private phone companies, to private shopping malls, to private employers, to private schools, or whatever else. Nonetheless, even though that's not a First Amendment matter, those private restrictions on speech, it might be a free speech matter. So for example, some states, one form or another, about half the states, ban private employers from firing employees for their political speech. My own California has a pretty broad such ban. It's not unconstitutional for an employer to say, we don't like your views about whatever subject, whatever political subject, so we'll fire you. But it is a violation of the state statute, just like it's a violation of federal law for private employers to fire people based on race or religion or national origin or sex, even though the 14th Amendment, which has a similar prohibition on the government, only applies to the government. Likewise, California bars speech codes by private colleges and private high schools. It's only California, but it's a big state. That's actually an important rule. And a bunch of cities, for example, ban private businesses from expelling patrons based on their political affiliation, sometimes party membership, sometimes political affiliation more broadly, sometimes their political speech. So with that, I'm done with my little introductory remarks. There's a lot more to be said about the First Amendment. I teach a a class that's basically 50 class hours during the semester on the First Amendment, of which about 2/3 are in free speech and the remaining third are in religion. So I could talk a long time, but we don't have a long time. So I thought I'd close the introductory remarks, and I see 21 items in the chat. So let's have a look. Let's look at the chat. Okay, hold on a second.
So there are
Okay.
2 questions that came in kind of close to what I'm thinking would be kind of the bottom of your chat. So I've tried to keep an eye on it, but there are 2 questions, one from Elizabeth and one from Jennifer, that seem to be kind of the big questions relating to what you just discussed with us.
Sure, I see them in the chat. Yeah, it turns out of the 21 items, most of them are hello, we're from Vermont or whatever else, which is perfectly fine. But there are at least 2 substantive questions. Does the libel exception apply only to persons or also to companies and corporations that now have standing as people in some legal contexts? So first, let's just a bit of history. There's nothing new about corporations being treated as persons from any legal rules. That's been around for well over a century, probably in some respects more than 2 centuries, but at least well over a century. And it makes a huge, huge amount of sense. So just to take an example, the takings clause protects people. It doesn't actually mention the word person, but obviously it applies to persons because that's who has constitutional rights, protects them from taking of property without just compensation. So the government can't take my house. All right, well, let's say my wife and I set up a corporation and we buy a little business and we open up a restaurant. And the government just said, we're going to take the restaurant. We're not going to pay you a penny. And when I said, what about my rights under the takings clause? I said, well, you're not, well, I mean, the property isn't owned by you, right? It's owned by the corporation that's owned by you. The corporation isn't really a human being, so nobody's rights are injured. Well, of course rights are injured. Even though there's this legal fiction of the corporation as a person, if you take the corporation's property, you take its owner's property. That's been long recognized. Likewise, for a lot of non-constitutional law, contract law, tort law, it makes perfect sense to treat corporations as legal persons with legal personhood, legal rights, and legal obligations. So the libel exception has for a long time applied to corporations as well as persons, because the kind of damage that knowing lies can cause to people can also be caused to corporations. So let's say, for example, people say some company that is making election equipment is in cahoots with the Russians, and it's causing it's allowing the Russians to hack into deliberately even allowing the Russians to hack into our elections. And that's all false. Obviously, that could be tremendously damaging to the corporation and therefore to its owners, to its employees, right? So the rationale for allowing libel claims on behalf of corporations is quite well established, and it's been recognized for a long time. The same thing, by the way, applies to nonprofit corporations. If you accuse, let's say, the Sierra Club of being in the pay of Putin, that Putin paid off the Sierra Club in order to lobby to reduce domestic oil production because that's good for Russian military plans because that increases the value of their oil. I'm just making it as a hypothetical. I think that's totally false, but let's say you say it just as a lie because you want to damage the Sierra Club. That's libel, that's punishable libel. The one kind of entity that can't sue for libel, it turns out, is government. Federal governments, state and local governments. There's a recent case from New York appellate courts, just tribal governments can't sue for libel. The rationale there is it's so important to be able to, for the public to be able to talk about government, and also perhaps so risky to allow libel lawsuits against the government, where it's essentially the government that's running the court system that adjudicates them, that as a general matter, governments can't sue for libel. If they are being lied about, they just need to respond and hope people are persuaded. So yes, a libel exception applies to individuals, to corporations, to religious groups, to nonprofit corporations, and the like. Okay, I get lots of questions about speech prior to the January 6th attack on the Capitol. Does Brandenburg v. Ohio apply? Well, it all depends on which particular kind of speech you're pointing to and whose speech, right? So just to take a particularly, just to take an example from there was a decision by a district court, federal trial court, that dealt with this very question in a civil lawsuit against President Trump and Rudolph Giuliani and various others for harm caused during the riot that was seen as, excuse me, the theory was that harm was incited by them. And the district court said, and it's just the district court, it's going to probably go up on appeal. Maybe it'll go all the way up to the Supreme Court, unlikely, but at least it'll go up on appeal where 3 judges are going to decide, not just one. But the district judge said, if I recall correctly, Giuliani's speech, this whole trial by combat, well, that's not really advocacy of violence. And it's not really likely to cause imminent lawless conduct. In context, nobody would think that is actually a call for violence. But they said Trump's speech, particular passages from it, might indeed be seen as that. So there's at least enough to send that to the jury. Not sure that's right, but at least one judge did take that view. But it just highlights the 2 things. First of all, the only reason we're talking about it is because it was a speech to a group of people that were assembled right there and were on the way, and perhaps were sent on the way to where within minutes or at most hours, they could engage in illegal conduct. We wouldn't be having this conversation if this were just a tweet that just said, you folks need to fight like hell to get your country back from the evil Democrats who have hijacked the election. That wouldn't have this element of imminence because it's talking to people about conduct at some unspecified future time, maybe when some of them are going to show up somewhere. That's not enough. But it's also helpful in all of these situations, all of them. It's helpful to think about what would happen if the shoe was on the other foot politically. And conveniently, the time period from 2021 brought us a lot of riots from a lot of people with a lot of political views, right? There were left-wing riots or far left riots, perhaps. There were far right-wing riots. There were people who were breaking into the Capitol, thankfully not burning it down. And then there were people who were attacking police stations or the federal courthouse, I think, in Portland, and indeed burning some of them down. So what would happen if somebody was standing in front of a rally, even a rally of people who are mostly peaceful, and saying we have to fight like hell to get our country back from the police oppressors. Let's walk down to the police station and show them what we're made of. Well, it's an interesting question. You want to look at the context, and it's conceivable that might be indeed incitement in some situations. On the other hand, if somebody were just to tweet out something that says police are abusers and oppressors, and anything we do against them is justified revolution, that would be a classic example of constitutionally protected speech. So, and where exactly any particular statement falls can often be, not always, sometimes it's quite clear, but can often be a pretty complicated question. Let me add one little twist. We talk here about incitement, but that's when we're talking about things that are relatively abstract. The more concrete you get, the less there is of a requirement of incitement or even likelihood. So let's take an extreme example. Let's say I say, I think you should kill so-and-so, whether because they're a fellow gang member and I think that's in the interest of the gang, or for political reasons or whatever else. I name the person. That may very well be purposeful solicitation of crime. And that's not covered by the incitement exception. It's covered by a different, less well-known, but quite well-established exception for solicitation of crime. And there, even if I say, look, don't do it now, we need to plan this. Let's think a little bit about it. And then, well, why don't you do it in a month or two when the person next comes to town or something like that? That could very, very well be punishable incitement. So a lot may depend on the specificity of the advocacy, in particular with the particular victims being targeted. Okay, where did the idea of the First Amendment emerge from? Why those 5 rights and not others? Well, it emerged from basically the experience of the English, that through the 1600s, the English were involved in a considerable degree of pushback against, if not quite absolutist monarchy that was aiming to be more and more absolutist. They lopped off the head of a king. They tried an experiment with a republic that, like so many experiments with republics, degenerated pretty quickly into military dictatorship. They had another bad king, and then they imported yet another one, and eventually they ended up with basically the embryo of constitutional monarchy, where the monarch was really quite constrained, of course, ever more with the centuries, but I believe the last time the English monarch vetoed a parliamentary passed law was basically 300 years ago. So they got started pretty quickly. One thing it took them a while to get is to get a really broad franchise. That originally only a small portion, tiny portion of the British electorate had the vote. Then that's broadened to basically most British men, I think by the early 1900s, maybe even late 1800s. In the early 1900s included women as well. In America, the electorate broadened somewhat more quickly, at least with regard to property restrictions. Those were largely removed by the early 1800s, and in some American states, even in the late 1700s. So, but in any event, the British had this experience with democracy. And one of the basic, I shouldn't say democracy, let's say self-popular government rather than monarchical government, or even purely aristocratic government. And one of the things that they pretty quickly concluded is if you're going to have a democratic government worthy of the name, but again, not even democratic, Republican government, if you prefer, back in a time when things were much more oligarchical, but a government where you had elections, let's say. It made no sense if you couldn't argue in favor of one or another side in the election. If members of parliament were being elected with an eye towards enacting legislation, it made no sense unless the public can talk about legislation, right? So pretty quickly, the British settled on, in an imperfect way, kind of stumbling towards the notion that there was a considerable amount of freedom of speech and of press, which is just to say speech through the medium of the printing press, that had to be allowed. There were a lot of restrictions imposed at various times in the 1700s, but the general sense was if you're going to have self-government, you need to have the people, whoever they were, whoever the electors were, you need to have them be able to discuss things. At the same time, there was the scientific revolution, the Enlightenment had been in full swing. It was also understood that speech and press were important means of spreading ideas about science, about religion. That was also a time when religious toleration became broader and broader. So the Americans took that ball and they ran with it. That in part because the American Revolution was itself created through free speech and free press. It was understood that free speech and free press had to be preserved in order that the people could govern, hopefully in a way that's less revolutionary than what they had to go through. There were definitely attempts to impose restrictions, but even those attempts, like the Sedition Act, which was quite oppressive in various ways, was actually quite liberal by the standards of the rest of the world, and even by the standards of England of not long before, and even roughly at that time. So that was sort of the general sense that the stumbling towards self-government, stumbling towards republic, that eventually became something much more democratic, in England, and then in the colonies, which became America, produced a set of legal principles that eventually gelled into free speech and the press. Why those 5 rights and not others? Well, because those were the ones that were seen as particularly important, particularly under threat from the government, and also particularly of concern, ones that it was particularly easy to make a consensus on, right? So, for example, obviously, the liberty from slavery is a more important right even than freedom of assembly, let's say. Freedom of speech is very important, and in a sense, slavery was abolished in large part because of advocacy, speech, and the press. But you could say that liberty of your own person from ownership by others is more important. You just couldn't get a consensus on that, right? On free speech and free press and religious freedom and lack of establishment, under some definitions, there was a consensus. Turns out there wasn't much of a consensus in the exact details, but at least the big picture was something that enough Americans of the era thought was acceptable, was acceptable and necessary. Okay. Let's see. A couple of other questions. For states that ban employers from firing employees for political speech, does that protect employees who promote extremist political organizations like a KKK or neo-Nazis? Well, so the answer is that none of these laws have any special exceptions, well, but not the KKK. That would itself be unconstitutional. The government can't just sort of say, we're going to protect some political viewpoints, but not other political viewpoints. However, different laws have different definitions there. Some of them, for example, only protect off-duty speech and not on-duty speech. The question also asked what specifically about employees who speak about or display symbols in their workplace. So some of them, even if you display non-extremist symbols in the workplace, the employer can say, no, we just don't want any possible tension because of that. Others say on-duty, off-duty, it's all protected. Some of them say, well, it's protected unless it causes too much disruption, which allows something that otherwise would be condemned as so-called heckler's veto, that speech can be, under these rules, if speech is sufficiently offensive to enough people, it can be prohibited. Well, in a sense, the reason for free speech protections is precisely to protect speech that does offend some people. Nonetheless, some of these laws, as well as the rules with regard to the government restricting employee speech, do indeed distinguish speech that sufficiently offends enough people from other speech. But again, courts can't say, well, we're going to have a different rule for racist speech than for other speech. If they do allow restrictions on racist speech, it's got to be on the theory that racist speech is just particularly offensive. And then the same principles would apply to, say, unpatriotic speech in time of war, which may also be equally offensive. But none of these rules sort of say, well, extremist speech, that's a different category, because that would be itself unconstitutional. Okay. Let's see. Somebody asks, Alonis. Okay, so Alonis is a case that dealt with true threats. And Alonis itself is a complicated case because it ended up dealing with interpreting the statute, didn't really resolve the First Amendment question. But here's the big picture. Everybody agrees, everybody, that is to say, all the justices at one time or another, and basically all the scholars that I know that have dealt with this, agreed that there needs to be an exception for threats of violence and probably threats of other kinds of crime. So for example, let's say somebody comes up to you in a dark alley and says, your money or your life. That's literally just words. If you don't actually give them the money, well, then the no money changes hands, so there's no conduct. Say they don't show you a gun. They just hint at its presence. So there's no conduct at all. It's pure speech. Everybody agrees it's got to be constitutionally unprotected. Indeed, the very first cases in which the court recognized free speech protections came in, I oversimplify here, but basically 1931. And by the early 1940s, the court was saying, of course, threats, not even of violence, but threats of, let's say, firing union members in violation of labor law would be constitutionally unprotected. But the question is, how do you define that? So here's one example. Here's one thing. Let's say somebody says to a political official, look, you shouldn't be enacting these laws because people are going to be very upset by these laws. And they're going to be so upset that there'll be rioting and maybe even they'll kill you. That's what's happened in some places. If enough sufficiently oppressive laws are enacted, then the politicians are viewed as oppressors and then they're killed. That could be a perfectly permissible warning, kind of like, look, this is just the reality. We've got to think about this. Or it could be an implicit threat, like, I'm going to be the one, or my buddies are going to be the ones who will kill you. It's a very difficult line to draw. I'll give you another example. There was a case called NAACP v. Claiborne Hardware. It was decided in 1982, but it was based on 1960s, 65 to 69. Litigation takes a long, long time in America. And there was in Port Gibson, Mississippi, there was a NAACP organized boycott of white-owned stores aimed at changing what was seen as racist practices by those stores and by the white establishment in Claiborne County. unsurprisingly, not all Black residents wanted to go along with this. Some of them thought, I have as much right to shop in those stores as white people are, and you guys aren't going to stop me. So the NAACP stationed store watchers outside those stores who would take down the name of Blacks who shopped in the stores, and then the names would be published in mimeograph sheets and would be read at meetings of the NAACP. And unsurprisingly, some of the people who were so listed were actually violently attacked. And Charles Evers, who was the head of the local NAACP, actually gave some speeches where he talked about the possibility that some necks might need to be broken and how the sheriff can't sleep with violators at night, which is to say can't be there to protect them. So the Mississippi court said this is a punishable threat and as such is civilly actionable. Supreme Court unanimously reversed, saying, no, in context, it isn't threatening enough. But again, an interesting question, why not? Is it that the threats weren't overt enough? Is it that there wasn't that much violence? There was some violence, but not that much. Hard to tell. So where those lines are drawn is itself a complicated and unresolved question. A lot depends potentially on this so-called mens rea or mental state. So there's been a big debate, and this is where the aloneness case came up, as to what happens if speech, or what does the government have to show? Does it have to show that you had the purpose of threatening someone? Is it enough that you knew that people would feel threatened? Is it enough that you were reckless about it, so you knew there would be a risk of threat? Is it enough that you were negligent? What if you're just, and sometimes this happens with kids, school kids, what if you're just sort of goofing around with your buddies and just joking about school shootings and you don't even think that somebody would feel threatened because your buddies all understand. But somebody, and you reasonably should have realized it, might overhear it or might see it on your Snapchat or whatever else and might feel threatened. So there you are negligent about the risk of threat, but you're not purposeful or knowing or maybe even reckless. That's an interesting question, which has divided the courts. The aloneness case, the Supreme Court was supposed to resolve it. It didn't. It only resolved it as to a particular statute where it said neither negligence nor purpose, something in between, hard to tell. And the issue remains one on which lower courts are split. So that's why they pay us lawyers the big bucks, because a lot of these questions are pretty difficult and it takes a long time to get them resolved. Okay, it sounds like the norm here is written questions rather than oral questions. I'm happy to take oral questions if people prefer, but maybe not. I mean, let's say maybe people don't prefer. So let me turn to some of the written questions. So one of them is currently teaching McCarthyism. How is the government able to prosecute individuals for controversial views given First Amendment rights? Well, the answer is most of McCarthyism did not involve government persecution of people for communist advocacy. There were a few prosecutions of top leaders for conspiring to teach violent revolution. Not just advocacy, but creating this nationwide conspiracy to teach it. And in a case called Dennis in 1951, I think, maybe 50, but I think it's 51, the Supreme Court said that's constitutionally permissible. And then towards the end of the 50s in 1957, it limited it pretty sharply to only apply to advocacy of concrete action and not abstract advocacy of violence. So the few people were prosecuted, but only a relatively few, and only really the top leaders. And current law, or since then, cases like Brandenburg retreated from that doctrine. The real force of McCarthyism happened in a couple of other paths. One was the government's power of exposure. So people were subpoenaed to testify in front of Congress, which Congress retains the power to subpoena people, and they were asked, well, were you a member of this communist organization? And who else was members of communist organizations? So the danger wasn't they would be imprisoned for this, although they could be imprisoned for refusing to testify, which they still can be. If you're ordered to testify before Congress or before a court, you've got to do it. But rather, if they did testify, or if they refused to testify, they would get blacklisted. They would get blackballed from employment from various other places in Hollywood, in the Academy, and so on and so on. So that was one thing. Another thing is they could be fired from some government jobs. And another thing was there was a good deal of private retaliation. So the Hollywood blacklist, that was Hollywood. It wasn't the government mandating that Hollywood fire communists. It was Hollywood saying, you know, we don't like communists. They're against our way of life. What's more important to a lot of our viewers of our movies don't like communists, and they're threatening to boycott us if we don't blacklist communists. So you're fired. And that's actually one thing that I'm seeing a lot of echoes of these days with a lot of the attempts to blacklist people these days. Some of them because they're just Russian citizens, so that's a separate matter. But because they're perceived as racist or anti-gay or anti-trans or whatever else. And often people say, well, but this is just private employers who are choosing to dissociate themselves from people who have views they don't like. And subject to those state laws that I mentioned, which are present in some states, but not others, you know, private employers do have that power to do that. But in many ways, that was exactly what happened during McCarthyism with the Hollywood blacklist and many similar things. And I think the judgment of history, more or less, it's never unambiguous, is that that was a mistake, that was bad for American democracy because it chilled not just outright Stalinists who said, yes, let's go murder tens of millions more people, but it chilled even people who were saying things that may tar them as fellow travelers or communist sympathizers or soft on communism or whatever else. And the result was an orthodoxy in universities, in Hollywood and other places where people were reluctant to express their views. And then we couldn't have serious debate about what to do about the Cold War. Or at least it would be a lot harder to have serious debate about what to do about the Cold War or what to do about economic inequality or whatever else. That was one of the reasons there was a lot of pushback, and I think rightly so, against McCarthyism and the blacklists. I'm seeing something very similar with regard to questions having to do with race, again, sexual orientation, gender identity, and such, even in situations where nobody's going to jail for this kind of speech. Okay. As social studies educators, how fearful should you be concerning your ability to teach the reality of our nation's history? Well, one thing to keep in mind, remember I talked about the government as speaker? Well, that means schools. Schools, generally speaking, get to decide what is taught, at least under the First Amendment. Oddly enough, that's not necessarily so with regard to higher education. And maybe that's wrong, by the way. Maybe higher education shouldn't get a special, maybe we professors shouldn't get a special break from normal legal rules that nobody else gets. But I do want to acknowledge that there are First Amendment rights of professors to say what they want in the classroom. That's just not true for K through 12 teachers, because when you're in the classroom, you're speaking on behalf of students. So if, let's say, your school says, you know, we don't want you to teach critical race theory, or for that matter, we do not want you to teach the possibility of biological differences between races or sexes in their let's say, intelligence or in attitudes or whatever else. Or we don't want you to teach dissenting views with regard to the Holocaust, or dissenting views with regard to COVID, or dissenting views with regard to the Civil War, or with regard to the Cold War. The thing is, teachers are hired by the schools to teach, and what they teach can indeed be dictated by their employers. Just as what an actor says in a script can be dictated by the producer. To be sure, one would hope that in order to have effective education, you're not micromanaged the same way, but some degree of such management is justifiable. So no, there is no general right under the First Amendment to teach in K through 12 schools the way you think it ought to be taught. I certainly think that as a matter of honesty and as a matter of kind of serving our students right, we should be teaching the reality, and we should also be allowing a lot of room for all sorts of possible views as well, rather than sort of just say, here's the orthodoxy that you teachers need to be teaching. But there's no First Amendment right, I think, of K through 12 teachers to choose what is to be taught or how it is to be taught. Okay. In politics, the Supreme Court has held money as speech. In this light, are there any limits in this connection? So I don't think the court actually held that money is speech. What the court held is restrictions on spending money are for speech purposes, are restrictions on speech. Let me offer a couple of analogies. At least so far, maybe it'll change in a couple of months, but at least so far, the Supreme Court has said that there's a right to an abortion. Let's say that a state said, okay, fine, we have to recognize the right to an abortion, no problem. But we don't want people spending money on abortion and paying for abortions. So what we're going to say is you can spend at most $100 on abortion and you can pay a doctor. A doctor can be paid at most $100 per abortion. That would be unconstitutional. But it would be unconstitutional not because money is abortion, right? It's because limiting the spending of money for abortions is limiting abortions. You take another example. There is, of course, a right of newspapers to publish editorials, including editorials about candidates, right? Well, newspapers, whenever they do anything, by the way, newspapers are almost all corporations. Whenever they do anything, they have to spend money, right? If you're in the New York Times, you can't do anything without spending money because you do things for employees and employees expect to get paid, right? So imagine that the government said, we just think it's unfair that big media has all of this power because of all of this money it has. So we're going to cap at $1,000 the amount of money that a newspaper or a television station or a cable, let's particularly focus on cable television stations, or a magazine can spend on supporting or opposing a candidate. That would be unconstitutional too, because that means basically that they couldn't really put out editorials. But not because money is press, right? It's because restricting the spending of money for press, which is to say mass communications purposes, is a restriction on the freedom of press. Likewise, restrictions on the spending of money to speak about politics are restrictions on speech, restrictions on political speech, because to be effective, political speech generally requires money. Now, the question is, are there any limits on this connection? Yes. Here's how the Supreme Court, rightly or wrongly, and it actually was a 7-1 decision back in Buckley v. Vallejo. Since then, there's been more dispute about it, but still, here's the line that the court has generally drawn. Contributing money to a candidate can indeed be restricted. Just like just giving money to a politician can be restricted. If I want to give a gift to a politician, that can be restricted in order to prevent essentially bribery. Because if I send my favorite, or not even my favorite, if I send a senator a $100,000 gift, I send them a Tesla, and say, here, drive this Tesla, and then call them up in a couple of months and say, oh, by the way, can you vote my way on something? That may very well be pretty close to, I'll give you a Tesla if you vote my way on something. And likewise, restrictions on contributions to candidates are treated pretty much the same. But restrictions on independent expenditures, like putting out an ad saying, I support this candidate or I oppose, those are generally cannot be restricted. And that's whether the restriction is on an ad put out by an individual, or as in Citizens United by a corporation, or as also in Citizens United, the same law applied to spending by unions. The government can't restrict that. And maybe that's wrong, but that's the line that the court has drawn. In part because, if you can't engage in this independent spending, you can't really engage in effective speech about which candidate you support or oppose. So it's not that money is speech. It's that restrictions on spending for speech are restrictions on speech. And the court has said that they are therefore presumptively unconstitutional. Okay, may have time for 1 or 2 more questions. Well, until when are we going?
So we can go until 7:30-ish, if that works for you. 7:30 East time. Yeah, sorry, I have to always factor in the time zone differences. So folks, I don't know if there's any other questions. We've kind of moved through all of them. I don't know if you're anything like me, but at this point you have pages and pages of notes. But any kind of final questions in our final 10 minutes together that we have? And again, you can feel free to unmute yourself and share your question verbally or send it through the chat if you're more comfortable that way.
But while we're waiting, can I just mention one thing that I just think is so important? I mentioned it already before, but it's obvious, so it's almost embarrassing for me to say this to fellow professional educators. but it's the kind of obvious that sometimes people miss. The single most important tool in leading students to think thoughtfully, think deeply, and think critically and self-critically about free speech is the hypothetical that flips the ideology in some measure. So, as I gave as an example, if you say, oh, well, obviously Trump needs to be thrown in prison for his incitement, you say, okay, fine, I can understand that. I can understand the argument for that. What if it weren't Trump saying this? What if it were somebody saying this with regard to a Black Lives Matter protest or something? Or alternatively, fake news. People say, well, of course we ought to be able to punish fake news by people who are denying COVID or whatever else. Say, okay, fine. But you know, what if the government is run by people you don't much agree with? I hear every so often that happens, right? For many of you, maybe the example might be President Trump. For many others of you, the example might be President Obama or President Sanders. Can you see, or do you think that it would make sense for a Trump administration to be able to decide what is and is not fake news? Another example is corporations. A lot of it, so obviously corporate speech is really damaging to public debate. Okay, well, so this is one of the issues right now. Should Facebook, should Twitter, should various other entities be able to use their massive economic power to kind of block what they see as harmful speech, supposed hate speech or anti-transgender speech or supposed fake news or whatever else? And if the answer is yes, of course, because after all, it would be horrible to force Facebook to carry on its property speech, things that it doesn't like, because that would violate its First Amendment rights. Well, then you might say, okay, fine. Well, what do you think about corporate First Amendment rights, right? Because if a corporation has the right to actually block people's speech, even on its own property, suggests that at least it has the right to engage in its own speech, which is less intrusive on other speech. So one of the advantages actually one has as being someone who knows about the First Amendment, as many of you do, is that actually every case is a possible hypothetical. Like for a lot of these things, I don't even have to come up with a hypothetical. Say, well, funny you should say that. Like you're saying, let's go out there and let's just make sure that nobody ever hires someone who said anything racist. Say, well, imagine we're in the 1950s, and imagine somebody said, well, let's not hire anyone who's ever said anything communist. Now, maybe your students don't know enough about the McCarthy era to be able to talk about it. Maybe you've taught them that. You might say, is that a good idea? And if it wasn't a good idea then, well, would it be a good idea now? Can we distinguish them? Is there some difference between communist advocacy then and allegedly racist advocacy today, or something along those lines, or allegedly communist advocacy then, allegedly racist advocacy today? But I find, certainly in my classes, that the key is always to ask the students to sort of think, what would happen if this shoe were on the other foot? Among other things, that's one way we got the very speech protective rules we have today, is that the court had seen a lot of these cases, said, wait a minute, we surely understand the temptation to restrict speech X, but if speech X is restricted, then speech Y is going to be restrictable too, just by the other side. Can we embrace that? And if we can't, then maybe both X and Y should be protected, although maybe in some situations, both X and Y should be restricted. So that's my tip. News you can use.
And I love any opportunity that we have to kind of figure out the ways that we can bring this amazing information back to our students. So that is a wonderful kind of wrapping up point, final thoughts on kind of this session, this part of our session today. And I haven't seen any questions come in through the chat still. Again, I will kind of pause just in case there is somebody who wants to ask their question. I want to make sure that I'm leaving space for that if that is the case. But I'm sure, again, everybody is kind of thinking about everything that was just shared.
I want to hear from the tiger. What is the tiger?
Sarah, the tiger just, oh, there we go. David Benson down there. That is a good picture to have on your screen. Okay, so if there are no questions, okay, so Jennifer Klein says, this is wonderful. Professor Volek. I greatly appreciate your insights, knowledge, and examples, and Jennifer said it better than I could. Thank you so much for sharing all of this amazing information with us tonight.
Very much my pleasure. And by the way, especially during COVID when nobody was out doing anything, I did a couple of talks to just high school classes. I think one in Alaska. Alaska is just as close as Los Angeles on Zoom. So if any of you are interested in having me give a talk about some of these subjects or about the Supreme Court, my experience of clerking on the Supreme Court or something like that, I'm generally happy, assuming the timing is right, I'm generally happy to do this.
Well, that's wonderful. What a wonderful offer to everybody. So again, Professor Volek, thank you so much for joining us today. This was amazing. And we all, I know, look forward to the opportunity to getting a chance to hear from you again. So thank you so much for sharing your time with us today.
Thank you, everybody. All the best.
Thank you. All right. And friends, I am going to stop the recording.